My guest today is Professor Anita Allen, who's Professor of Law and Professor of Philosophy at the University of Pennsylvania Law School. She's an expert on philosophical and social justice dimensions of privacy and data protection law, ethics, bioethics, legal philosophy, women's reproductive rights, and faculty advancement. Welcome, Anita.
Thank you so much.
Yeah, so thanks for doing this. So I want to set the context for our conversation. I want to use your presidential address delivered to the American Philosophical Association in 2019, in which you talk about many of the topics we want to talk about. So you start off here saying American life, indeed global human life, has gone digital. The ways in which people act and are acted upon directly and indirectly rely on digital technologies. Yeah, so when I think about privacy, I don't know much about this, Anita. When I think about privacy, I think about two different things. I think about
Okay.
sort of the electronic stuff, the surveillance and who is looking at my data stuff. And then I think about HIPAA, and we'll talk about that a little bit because I did some work in the healthcare arena with
Mm-hmm.
primary care and behavioral health, electronic medical records. And so, I didn't realize HIPAA is 25 years old now. I thought it was much, much newer. And so in here you say sort of the different types of privacy categories, which I wasn't aware of at all. So you say about six different categories of privacy you can think of.
Yeah. Thank you. So, when people hear the word privacy, they do bring to the conversation different understandings of what privacy is. But I began in the 1990s trying to get a more comprehensive view of what are the different meanings that people attach to privacy. Because I want to be able to say succinctly, these are the four types of privacy, or the five types of privacy, or the six. And so over the years, starting with my study of genetic privacy, actually, I I came to recognize that there are sort of six different conceptions of privacy, all of which are manifested in the law. And so that means that they're also manifested in our culture because the law, of course, is based on our culture. So there's physical privacy, the privacy that's at stake when someone's a peeping tom looking in your bedroom window, for
Mm.
example. There's
Or
informational
video cameras and stuff like
or
that, right?
video cameras,
Yeah.
yes, installed in your workplace or on the streets even. That can be a form of physical privacy. Um, Informational privacy, the sort of privacy that's at stake with access to our social media records when we pass away, for example, or HIPAA medical record privacy is a good form of informational privacy. And then there's decisional privacy, which is the kind of privacy at stake with the abortion right, gay rights, the idea of being able to choose autonomously the way in which you live and the choices that you make. So those are the top three. There's also something I call proprietary privacy, which is the privacy that we have in attributes of our personal identity, our faces, our names, our likenesses, our identities in general. There's intellectual privacy, the privacy of the content of our minds and our thinking. Um, and so the last form that I would recognize would be, I call it associational privacy, the privacy
Mm.
to meet with people of your own choosing in social organizations, political groups, and so forth, without the interference of the government or other people. So those are the six forms of privacy that I recognize. Other scholars might give different names to those
Mm.
same ideas, but I think that the ideas themselves are pretty uniform, and that you can use my taxonomy or someone else's taxonomy. But I think we're talking about a distinctly common range of topics under
Yeah.
this rubric.
So decisional privacy, that is, I haven't been thinking like this at all, actually. So abortion rights. So there's sort of an intersection between rights and privacy in some ways, right? So are the laws in conflict? So if they were privacy laws against other types of laws, do they come in conflict in situations like abortion?
Well, they come into conflict very often. I mean, the abortion issue for some people poses a conflict between the pregnant woman's right to privacy and the right to life of the unborn fetus or embryo or child, right? And so there's that kind of conflict. But there are other contexts in which there are conflicts between privacy and things that we value. For example, privacy often conflicts with the First Amendment.
Hmm.
Um, I've been teaching this week about some privacy issues where there are a lot of First Amendment problems. So, for example, suppose that a magazine um, publishes a parody of someone that's very cruel and vicious because it makes them look like they're unintelligent or morally retrograde. Well, unfortunately, the First Amendment gives a lot of protection to the publication of information and of artworks and of parodies and of news. And so the individual may feel their privacy is invaded because they're being their identities are being captured. But yet the First Amendment does protect a wide variety of speech type interests such as news, art, and other sorts of free expressions. So yes, the conflicts are common, and
Everywhere.
we have to deal with them. And part of the job of the law is to help to balance out some of these competing interests and to provide a path forward for society.
Yeah, I was just as you were talking, I was just thinking about, sort of, the second, the right, the gun rights are in Second Amendment, right?
Yes, yes, yes.
And so, there's some states that allow you to carry a gun, or I don't know exactly, concealed carry or whatever they call it. Um, is that a privacy issue as well?
I love the question
Yeah.
because one of the things which I have insisted upon is that our Bill of Rights is a very, very powerful source of privacy protections. And many of the first 10 amendments to our Constitution implicitly protect privacy. The
Hmm.
First Amendment by free association. The Second Amendment, the gun laws actually have been by some of our courts held to protect the privacy of the home and decision making about the home
Hmm.
because some of the big Supreme Court cases involving guns, the Heller case comes to mind, have found that people have a right in their home to possess a gun that's used for the protection of their families. So
Hmm.
even the Second Amendment, which is very different from abortion rights or digital informational rights, has been found to have a privacy dimension to it, along with
Hmm.
search and seizure under the Fourth Amendment. The rule against quartering soldiers in war in peacetime is the Third Amendment. The Fifth Amendment, right against self-incrimination, is the right to not disclose our private thoughts to the state. So many of the Bill of Rights amendments actually have to do with privacy, even though the word privacy is nowhere
Hmm.
in the Constitution.
Yeah, so it sort of runs through the entire system, so to
Yes,
speak. Yeah.
yes, yes.
Um, and so I want to go into, some of your specific papers. Um, so you have one on HIPAA, and even though I have done some work in healthcare, I wasn't really aware of all the history. Um, and so HIPAA is the Health Insurance Portability and Accountability Act of 1996. So we put this together very early. And you say here, which was a step toward greater health information privacy. It turns 25 today. US health disclosure norms are changing with openness and sharing becoming more commonplace. So, electronic medical records, for example, um, as sort of a guy who does some computer stuff, we use electronic medical records to make predictions of patient health and things like that. And obviously, we use de-identified or anonymized data to do that. So obviously, we don't know who the patient is, but we have some sort of aggregate information. Now, I think you have a slightly different view on this, right? So how should HIPAA change, or is it in a pretty good shape right now?
Okay, so HIPAA is a product of the 1990s. that was the period in which we were still trying to map and sequence the human genome, but there was a sense that in the future there'd be a lot of highly sensitive information that needed to be portable and secure. And so HIPAA has this foundation, I believe, in a different era when we were much more concerned about keeping health information away from the world and not with sharing it to exploit its benefits.
Yeah,
But
sorry to interrupt, Anita. So
yeah,
1996, we haven't had internet in full flow in
exactly.
1996.
That's
Yeah,
absolutely correct. We did
yeah,
not have
yeah.
internet in full flow, and so imagine what Congress was thinking about and wasn't thinking about in 1996. And so one of the reasons why a lot of people think that HIPAA is younger than 25 is because the privacy rule and the security rule were not implemented until the early 2000s, until around 2003, 2004. So HIPAA feels newer, but it's also been, as I point out in my article, it's been changed. Like every time we have a new administration, HIPAA is changed. It's
Yes.
it's it's a it's a it's a moving target. And but the
Yeah.
changes that I see in HIPAA are toward making it easier and easier for people to get access to the data, because now, unlike in 96, now
Yeah.
our big concern is let's exploit AI to be able to
Right.
create new therapies, new drugs, new interventions. And so the direction of HIPAA, I think, is towards loosening the grip on health information. And that's a different HIPAA than I think some people thought we were going to have back in 1996.
Mm. Yeah. So this is very interesting phenomenon. So they were very forward thinking in 1996. They couldn't anticipate what could have happened last 25 years. Now we are in a very, very different world. And raw materials in every domain as data.
Yeah.
And data is useful in many ways, but then there's a downside to that, right? So,
Yeah,
yeah,
I mean,
yeah,
one of the problems that I see with HIPAA is that although you as a professional understand that the HIPAA law does not prevent researchers from getting access to this information, a lot of ordinary people don't realize that many, 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 many actors beyond just their doctors and their nurses and their therapists can get access to that information and use it. And I think we need to be a lot more open and
mm,
honest with people when they sign those HIPAA, HIPAA waivers about what exactly they're giving consent to, because I don't think people understand that. I'm
mm,
not saying that they wouldn't agree anyway, but I do think that it's important that people have a realistic sense that their health data is not in some vault somewhere where only one or two people with a key can get inside, but instead that many, 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 many insurance companies and their affiliates and the doctors and many doctors and the government and maybe even the police in some situations can get
mm.
access to their health data. So we just need to be more open and honest and transparent about it.
Yeah. So it's a little bit of an education issue there. So when I walk into my primary care physician, I sign many one pagers. I just
Yes.
sign them, but I don't
Yes.
actually read what is in there. And it's basically saying, yeah, data is sort of usable in many
Mhm.
different contexts.
Yes.
I was reading, Anita, some time ago that perhaps the way to think about this, I just want to throw this out to you and get your perspective. If data is monetizable, and if the patient wants to give the data to somebody or for something, maybe the patient needs to get paid for it. It's sort of a similar concept on Google or wherever. If you want my data, I might consider it, but you have to pay for it. That monetization doesn't exist. It's either they just take it and use it or don't, right?
Yeah, and I have mixed feelings about monetization because, on the one hand, right now there's this perversely we're paying to give other people our data. So if I want to give 23andMe my genome, I have to pay them $100,
Yes.
and they
Yes.
pay me nothing, right? So that's perverse. On the other hand, I don't want people to devalue their privacy because of the attractiveness of getting $100 or $20 or $300. And I feel that we do have a problem culturally that people are losing their sense of the importance of privacy. And I think monetization might give people the sense that, oh, it's just a commodity, it's just a thing, it's like ice cream, fast cars, whatever. It's not that important. Whereas I believe that privacy is a deeply important value that ties into our dignity and our autonomy as human beings. And I'd hate to see people just toss
Mm.
away all of their privacy for a few dollars, you know. And I think if we do have monetization, it's going to be that a few dollars. It's going to be
Yeah.
undervalued and
Yeah.
by everybody concerned. That bothers me.
Yeah, I mean, it's a real asset that is very difficult to value
Hmm.
for ordinary people. And so there's a pricing question.
Yes.
And so that may not be a very efficient process. But I think you also have some concerns. So, we've been using these terms de-identification, anonymization of data. We are just looking for aggregate patterns in patient data. But you have some concerns about that as well, right? In the current HIPAA construct.
Well, I'm not an engineer, so I don't feel that I'm necessarily the best person to comment on this. But I have read studies suggesting that it's way too easy to re-anonymize the de-anonymized.
Mm,
And then I also have concerns about whether de-anonymization is enough because as an African American woman, for example, not only do I not want my personal data to be used by racists to try to prove that black people are not intelligent, but I don't want the community to have the data that they would need to make those kinds of claims. So that it's
yeah.
the fact that it's de-anonymized doesn't solve the problem that certain data, in my view, should not be available to certain
Mm,
people in any event, right? So and I don't know quite how to put that in a way that resonates with everybody, but I'm just
mm,
concerned that it's beyond just what an individual might
mm,
wish or want to be exposed to. It's also about whether groups of people defined as maybe women perhaps, or poor women, or women with high blood pressure, or I mean, you can sort of
mm,
define these categories we might belong to, where having those that grouped de-anonymized information might still have implications for certain subcommunities that might want those subcommunities to therefore not welcome
mm.
the data being used, even if de-anonymized,
Yeah, that's so interesting.
even if
So,
anonymized. Yeah.
yeah, so what you're saying, if I understand this correctly, Anita, is that the risk of information revelation is different for different people.
Yes.
So, in some sense, suppose we have some sort of macro concept about privacy, it doesn't quite work because privacy is private in many ways, because you have to assess the risk of losing privacy, and different people have different risks, it looks like. Right? Are you aware of this case I don't want to mention any company's name, but it's an insurance company in New York, found that African Americans required less care using artificial intelligence, and the way that they reached its conclusion is that historically, African Americans received less care. And hence I predict they require less care. So yeah, I mean, you mentioned AI. I mean, there are a lot of technologies running around, changing the world is going to going to change. But there's a lot of risk that we haven't really measured properly, and it's individual specific in many ways, right?
Yes, and I mean there are risks we haven't fully understood. There's also the problem that garbage in, garbage out. That problem, discrimination in, discrimination out. That's a sort of a general problem. But so I wanna to mention a couple of things that are responsive to your last question, but also go back to something you were talking about earlier, and that is that we uh, we talk about privacy as if um, it's about free choices only.
Mm,
And if people choose or don't care, then we shouldn't care either. But I have a very different view of privacy. And I wrote a whole book about this called Unpopular
mm,
Privacy: What Must
yeah.
We Hide? And the theme of that book was that some forms of privacy are not popular, that people don't care about them. It doesn't mean that they're not important. And so that we need a kind of I would use the term paternalistic understanding of privacy to make sure that we don't just as a society, allow it to become so degraded, so devalued, because people happen not to care. And they're not caring not only because they inherently don't care, but because there's so many pressures on people to not care. If you can not care about your privacy but get to be on a TV show, Big Brother or some TV show where they're constantly, I mean, that there's incentives to not care, and we're training our young people to not care about their privacy, and that worries me very greatly. So if you have that problem going on, people being trained and educated, um, to not care about privacy and not caring about privacy. And then you have researchers who are involved in AI, um, not being sufficiently sensitive to the ways in which the data sets are creating these false narratives about what's important or about what's possible, what people value. I mean, the combination of those two things to me is deadly, and I think that's why I live in terror.
Yes.
Because I think it's a very tricky time. We need to get a grip on these problems before they get out of hand.
Yeah, as you're talking, I was thinking you're an educator, so should we have like privacy 101, like physics 101 in undergraduate? Uh,
So in law school we have privacy 202. So we are teaching privacy law to law students now. Most of the big law schools and the important law schools have privacy curricula. We have it at my institution at Penn. It's taught at most law schools. And I said I shouldn't have used the word important law schools because there's no unimportant law school. But what I meant was sort of size and prominence. But many law schools have valuable privacy curricula, and that's a good thing. It's not creeping down into the undergraduate education as much, though.
mm,
I mean, I have from time to time taught undergraduate ethics and included some materials on privacy in undergraduate ethics classes to, I think, great effect. In fact, when you asked me that question about guns and the Second Amendment and privacy, I was reminded that many years ago I was teaching an undergraduate seminar at Princeton, and I asked the students to give me some examples of the right to privacy, and one of the very brilliant Princeton students said, gun control as this example. And
yes.
that gave me an opportunity to talk about privacy in that seminar. But yeah, it's not taught early
Mm,
enough. There are some undergraduate debate teams, even high school debating teams are using privacy topics. I've been asked to
mm.
to judge some of these competitions. So it's starting to happen, but we don't think of privacy as a basic subject matter. And
Yeah.
gosh, you make me think maybe we should. Maybe we should.
Yeah, it's a complex topic. So I want to go into another paper that you have, Synthesis and Satisfaction, How Philosophy Scholarship Matters. So this is very interesting to me. So privacy and technology clash in the course, you say here. I elaborate the example of Puttaswamy versus Union of India 2017, an example from the High Court of India where sweeping and inclusive style raises starkly the question of the influence that academic philosophers and other scholars have over how legitimate societal interests in exploring information technology and protecting personal privacy are balanced by the court. So yeah, I mentioned Anita. I grew up in India. My parents still live there. I think they both have this. I mean, you're going to talk about this uh, thing that they did. It's called
The
Aadhaar
Aadhaar
card.
card, yes.
Yes.
Aadhaar card, yes.
So both my parents have it. So I didn't really know how it all came about and what the legal implications were. I don't even know what the current status is. So have you been following what's happening in India from
Yeah,
citizen? Yeah.
yeah, yeah. So uh, the Aadhaar card is a kind of, you might call it a national ID card. It's an identification card that Indian citizens can obtain, and some of them must obtain to access public services and facilities. The card is created by collecting iris scans, fingerprints, and then
Mm.
demographic information and creating a number. And so when this was announced
It's like a
originally,
social security, like a social security number. So,
Yes, except
yeah.
biometrics are used to create the
Yeah.
number. Whereas, you just get a social security card, you fill out a piece of paper, you go online, you type in information, but you don't give them your iris scan or your fingerprint. So
Yes.
this is a
Correct.
much more
No, not
privacy.
yet. It might be coming anytime.
Maybe it's coming. Maybe it's coming. But the U.S. has resisted the national ID card movement for many, many years. But the Indian version of it was intended to make sure that the resources of one of the world's largest democracies were properly spent on people who were actually citizens, and so it made a lot of sense. Um, but privacy experts around the world went bananas at the idea of a biometrically based ID card, and then even some people in India went bananas. And so the named plaintiff in the suit, Puthuswamy versus Union of India, Mr. Puthuswamy was a former judge who
Hmm.
found this ID card very, very offensive, and so he led the charge against it, trying to claim that it was an unconstitutional invasion of privacy. But
Hmm.
the problem was India didn't have a constitutional right to privacy that he
Hmm.
could hang his hat on, and so he and his lawyers had to craft the idea that there's protection for privacy under the Indian Constitution. And they succeeded because when the court looked at the case, they wrote a very long, I think, 200-page opinion in which they said that the language of dignity in the Indian Constitution is the foundation for a right to privacy.
Hmm.
And this was for me thrilling because they cited my work to help to defend the idea of rights to privacy being fundamental rights, important rights, not just human rights, but the kinds of fundamental rights that any democratic legal system ought to include. So I'd never been to India. I didn't know Indian lawyers. And so imagine my surprise when someone called and said, Anita, you're cited by the Indian Supreme Court. So that made me very interested in the Indian Supreme Court and the jurisprudence of the court. And I've been following it ever since. And so not only did this decision in the Puthuswamy versus Union of India case give uh, Indians a right to privacy that could be used to critique the Aadhaar card. But then the next year, it was used for gay rights to extend gay
Hmm.
rights to
Hmm.
Indian LGBT people. Uh, Perhaps not all the LGBT problems in India have been solved, but at
Hmm.
least now there's on record a Supreme Court decision saying that there is a right to privacy to engage in same sex
Hmm.
on the national level. As far as the Aadhaar card goes, though, although the court found the right to privacy in the Constitution, they didn't strike down the Aadhaar card as itself a problem because they argued that there were many protections built into the way the card was being used and
Hmm.
developed that meant that while there could be a privacy problem, there wasn't one yet. There wasn't one. It was being
Hmm.
handled well. And so the card, your parents have the card. My Indian friends who live in India have the card. My next door neighbor who's from Mumbai has the card. Everyone has the card, and it's as far as I know, it's being used pretty responsibly. I will note this one thing, and then I'll shut up and let you ask me another question. But this is such an exciting topic for me. I did have an opportunity to have a little symposium at my law school on the Puthuswamy case, and one of the women in the audience pointed out to me that she supported the Aadhaar card because of the problem of women and girls disappearing, being lost,
Hmm.
and that if children uh, uh, who are female, women are have the Aadhaar card, it's easier to track and trace them. If they have to show the Aadhaar card at certain key points, then people can't change their identities, kidnap them. And I thought this is a very interesting. I don't even, I mean, know
Hmm.
how serious this problem is, but apparently in the mind of these folks who came to my symposium, it's a serious enough problem of the disappearing girls and women that the Aadhaar card seems like it might be a useful thing, quite different from the reason why it was developed, but a useful side benefit is that people don't get lost. People can be accounted for and identified.
Yeah, that's really interesting. So clearly, I mean, it's a developing country with 1.4 billion people, really large country,
Mm-hmm.
and it has its own, sort of growing pains. My grandparents were freedom fighters, and when the Constitution was put together, I mean, it's a very young country in the
Mm-hmm.
grand scheme of things.
Yes.
Um, they seem to have had some ideas, but the population grew quite rapidly, and now they are at 1.4 billion. So there are some sort of structural mechanical issue
Mm-hmm.
for the country. So this is where I think you talk about this here, that it's sort of, I mean, we have great technologies now, and can we use technology to affect people's lives is really the question.
Yes.
But then the downside, I'm very conflicted about this, Anita. I don't know which way to go.
Uh-huh. Uh-huh.
But
Uh-huh.
there are downsides to it, right?
Yeah, I'm conflicted as well about about the use of the Aadhaar card and similar technologies of governance because we know that when governments can identify people and keep track of people, it sometimes goes south. We think about World War II. It's always a great fear that we're going to enable some government to do some harm to large groups of people who happen to be unpopular because of their religion or their culture or their background and some other things. So we worry about that, and I think that we have to keep worrying about that.
Hmm.
Um, and so right now with there is ethnic conflict and religious conflict in India, and I would hate to see an ID card becomes a way to keep track of people in ways that are cruel or malicious, right? On the other hand, I do understand the need to keep to manage the problem of delivering services to the right billion
Hmm.
people, and not to those who really should be cared for by some other government or be outside the systems in some other way. Yeah.
Yeah, I was just thinking that unlike the US, when you have your name on something, whatever your religion, your caste, or whatever, right? Um, there's a lot of information there, unlike the US, because it's a pretty sort of a
Mm-hmm.
country where the name tells you everything. I
The
mean,
name can tell you a lot. Yes, yes.
so
You
you
know,
don't
and
even need anything else. You just need your name and age and that type of stuff, basic demographics. And so, yeah, I mean, it's a democracy. I would argue barely so in the
mm,
last 10 years,
mm-hmm, mm-hmm,
where a political party could potentially use that type of data to target those types of things. So yeah, I really do worry about that. Yeah. So it's almost like when you have a developed country. So if I go to Budapest or something and I lose my American Express card, American Express is going to call me. Say, hey, where are you? uh, and that's useful in many ways. So how people of a developed country behave, or how organizations and structures of a developed country operate, are quite different from a developing country, right? So there's sort of a potential risk in moving in that direction. I think I haven't really
mm.
thought through this. Yeah.
But even in the United States, there are groups that are concerned about government access to racial data, for example. Um, so back in the 1930s, when the Social Security card was being developed, many African Americans opposed the idea of a Social Security card that would
Hmm.
put racial data in the hands of employers and the government systematically because we'd been suffering too much from being singled out for discrimination. This is gave a tool for discrimination. And even today, there are some African Americans who believe that being off the grid is better than having some sort of uh, identity that the government has access to and can
Hmm.
find you and can control you. So it is a developing versus non-developing country distinction. But even in the so-called developing country, there can still be subgroups that have concern, like immigrants. I think immigrants in the United States from the global South have cause for concern about being too identifiable, about being too visible, right? African Americans still have some fears about being too visible. So it's a problem that we haven't really completely solved, and it's a tension because there are benefits to being visible and there are benefits to being invisible.
Yeah. Yeah. So next paper is sort of a continuation of the same idea. So dismantling the black opticon, you say here, privacy, race, equity, and online data protection reform. So I haven't, been really thinking about this deeply. So you say here African Americans online face three distinguishable but related categories um, of vulnerability to bias and discrimination that I dubbed the black opticon. So what are those vulnerabilities online for African Americans?
Hmm. So before I tell you what they are, I will tell you that it was my goal to come up with a succinct way to communicate the vulnerabilities that I think are typical of African Americans and Black Americans in general. So there are three vulnerabilities. One I would describe as the panoptic problem of being over surveilled, over surveillance. I do think that many African Americans feel and are as we talked about, being too visible or overly visible because of where we put cameras, which institutions we monitor, which careers and jobs we monitor, which people we monitor, who we stop at traffic lights, and so forth. So,
Hmm,
so the over surveillance is a problem, and the facial recognition problem is one which is often grouped in this category. The idea that you have a technology, it works well for white people, it doesn't work so well for
hmm,
Black people. The wrong people get arrested, and it's a problem of over surveillance. It's also a problem of mis-surveillance, right? Wrongful surveillance. Anyway, so over surveillance, which I call the panoptic threat, is one type. The second vulnerability is um, discriminatory exclusion. So,
hmm,
so it's being uh, deprived of opportunities that are available to white people, for example. So if you go online, but you're not getting the same advertisements for mortgages or
hmm,
educational opportunities or jobs that are targeted at white people, that's a kind of exclusion that is sometimes called the banopticon or the banoptic problem, because the people
hmm.
being banned from the sight lines of civil society, and that's a problem. And then the third vulnerability is one which I've come to call the conopticon, because people of color are subjected to con jobs, scams. They're vulnerable to predation, and the government itself, the FTC, has issued a report which describes in great detail the ways in which Latino Americans, some Asian groups, are subjected to discriminatory predation. They're targeted because of their vulnerabilities. They need loans, they need education, they need jobs. It's easy to manipulate them into buying things that are not in
Hmm,
their interest, it's all happening because the data is collected about who they are that enables us to know, well, who is Hispanic, who is Black, and so
hmm.
forth. So discriminatory over surveillance, discriminatory exclusion and discriminatory predation. Those three things together are what I describe as the Black opticon. Um, yeah, that's the
Yeah, so,
framework.
so from a sort of an engineering perspective, Anita, so when a system has a lot of stress on it from multiple angles, so talked about surveillance, exclusion, and predation. There is sort of a combinatorial effect from all those things on the individual, right? So, I mean, we can disaggregate the effects and we can try to sort of mediate one or the other,
Mm-hmm.
but we cannot really mediate the combinatorial effect on the human being. And I think that is a fundamental issue that we're dealing with, I think.
Yeah. Some folks point out to me that we have had some success through existing legal structures of addressing the Black opticon. So, for example, the federal government has gone after Facebook for discriminatory advertising, for example, and the FTC has gone after some companies that have been engaged in discriminatory predation. So sometimes government can actually be a good force for knocking down some of these particular problems. But I think that so far the government has sort of just touched the tip of the iceberg. It's a much
Hmm,
larger problem that's going unaddressed. You have a few high-profile cases involving Facebook or some other major social media companies. But the big problem of this sort of mostly hidden set of abuses online are not really being addressed by these government agencies thus far. We need to really be
Mm.
more proactive and dig deeper in order to uncover some of these and to deal with them. Um, I should note that not only is there a Black Opticon, but some of my students have begun to expand the Black Opticon to apply to other groups. So one of my doctoral students is writing a dissertation on what he calls the queer Opticon, arguing that LGBT people are also subjected to over surveillance,
Mm.
discriminatory predation, and discriminatory exclusion. And then there are scholars around the country who've said that the same Black Opticon framework can help us to understand some of the problems that non-marginalized groups experience,
Mm.
with the digital platforms. And then when I was in Europe recently, I was introduced to a case in the Netherlands involving a Netherland resident, a Black Netherland resident who was having to take her exams online, and the software that was used to identify the students who were taking exams online
Mm.
couldn't recognize her because she was dark skinned, and she
Mm.
brought a lawsuit against the university that was using the software, and she lost the lawsuit, not because they didn't agree that there was a problem, but because she couldn't prove that she had actually done worse on her exam because it took her longer time than white people to get set up with the software.
Mm.
But I think the idea of the Black Opticon is not just limited to Black people. It's an idea of there being certain predictable, recurring ways in which people, I think especially marginalized groups, but people are disadvantaged, and that we need to do something about it.
Yeah, I mean, no, I'm just wondering, why are we here in 2024? We have all been enlightened, I would imagine. I don't know. So what is your view on, if you take a sort of comparative analysis of nations around the world, um, are we sort of at the bottom of the pile in some ways? I look to Japan. I see New Zealand. I see some of the Scandinavian countries, and I feel like they have gone further than we have.
Mhm. So I had the pleasure of teaching for 2 summers in Japan at Waseda University, and teaching about privacy law there to the students, and talking about privacy to at public lecture events. And it seems to me that the relative homogeneity or felt homogeneity of the
Uh,
population
yeah.
is a protection, because uh, while there's discrimination against Korean ancestry Japanese people, and there are
Mm.
relatively few other distinct minority groups in Japan in large numbers, I think
Mm.
that these problems are less severe, or feel less severe. I think the same thing is true of Scandinavia, although that's becoming increasingly not so true of, say, Sweden, where there's now
There's
a
an
lot there are a lot
interesting
of
experiment. Yeah.
immigrants, and I
Yeah.
wonder whether there will be more discussion about the Black Opticon in Sweden as the number of
Yes.
immigrants
Yes. Yeah.
from Asia and Africa come to live in that country. So I do think that you happen to name some countries that are particularly homogeneous in their population, and I think the
Yeah.
United States is not only uh, so multicultural and diverse, but it has this history of slavery and colonialism
Mm.
that that we're still growing out of, and we haven't completely grown out of. So we still have massive
Mm.
prejudice and discrimination based on color and national origin and race.
So suppose mathematically we find that having uniformity is a great advantage from a policy perspective. Then should we actually take 330 million people and put them into, let's say, three or four buckets and have three or four different countries? Would we be better off?
You know, during the I think it was probably in the it was I think it was the early 2000s or late 1990s when there was a big controversy over um, the Icelandic genome being put in the
Yeah,
hands of private actors to to use for analysis, and that.
but longevity, right? Longevity was the yeah,
Yeah, yeah,
yeah.
and the idea that Iceland was this sort of remarkably homogeneous, genetically homogeneous population because it was so isolated from the rest of the world, and it's et cetera, et cetera. And some people were there was some pride in the Icelandic
Hmm.
genome being so quote unquote pure, but there's also some worry that valuing populations and the potential of populations to tell us some information we might want to know as scientists
Hmm.
because of their isolation and quote unquote purity. It was a scary thought, right? Because it's a it suggests that there's isolationism and maybe even discrimination. And there have been problems in Iceland about, for example, can the black soldiers, U.S. soldiers who were stationed on Iceland, uh, mingle with the general population in Reykjavik? That was actually an issue when I was in Iceland
Hmm.
in the 1990s. Can black people mingle with the general population? We want to preserve this homogeneity. So I'm not welcoming of your of your idea. Also, your idea reminds me of the fact that even some black people felt, in 100 years ago, that the way to solve the problem of recovering from slavery would be for black people to relocate back to Africa, to be there. And when I've done my own genetic analysis through 23andMe, and I am substantially, I guess you might say, Nigerian. My people on both sides of my family come from what would be today considered Nigeria, but I have no cultural tie to Nigeria. And it would
Hmm.
be bizarre for me to move to Nigeria in order to be closer to people like me, or to be forced to move to Nigeria. So it's not a very practical idea, but I understand your point, which is that, if the world happened to be a world in which people were living in little little buckets of same kind genomes, would we be in some sense better off from the point of view of science, but also from the point of view of getting along better and being free from discrimination? But that
Yeah,
ship has sailed. I mean, we're a global globe, and
yes,
we can't put that genie back in the bottle.
yeah. That's interesting idea. So, as I mentioned, I grew up in South India, and it's not known that my family ever left South India since before I came to the U.S. To go to graduate school. When I do my genetic test, I get Rome, Netherlands, Spain, and Portugal. Yeah, and that is also sort of an educational access. I mean, there have been
Mhm.
a lot of traffic, obviously, from
Mhm. Mhm.
Europe into India,
Yeah.
and I suspect my family was very welcoming. Anyways, it is a thoroughly mixed population, and so
Absolutely.
yeah,
Yes.
yeah.
Yes. I mean, I have two children whom I adopted, and who would be described as black, but their genomes say something similar to what your genome says, which is that
Yeah.
my son is substantially Russian, mostly Russian. My daughter is mostly
Don't tell
Swiss
Putin.
German. Don't tell Putin that he has a black cousin. Yeah, but seriously, I mean, we are so mixed, both in terms of at the genetic level, but also at the cultural and national level. We are just mixed, and I think it's, to me, that's a wonderful thing. I celebrate the diversity of the United States. I think it's a great thing. I love my country in part because of its diversity, um, and I would be less happy to live in a country that was less diverse, especially
Hmm.
if there were forces that were keeping diversity out on purpose, right? Out of some
Yeah.
belief that somehow we would be better off if we all looked the same, or sounded the same, or spoke the same language.
Yeah, I'm with you. And I think we should stay at the 330 million people for now. We'll see after November. Maybe
We'll
there's a
see. We'll
civil war
see.
that breaks out after that. Who
I
knows?
think
But
I
yeah.
think we're all a little bit afraid of what might happen in November, in all seriousness, and some of it relates to the fact that we haven't been able to use either culture or science to address these problems of difference that pop up so much, and some of them do get expression through our privacy woes, but not all of them do, but many of them do.
Hmm. So we're running out of time. So I want to finish up with, maybe this is not the paper we wanted to finish up with, but that's where we are. Postmortem privacy. Yeah, you say here, since their inception in the late 19th century, privacy rights has been widely understood to terminate with a person's death. The no privacy right for the dead doctrine has been repeated for nearly 130 years. You say here, as demonstrated in this article, the reality on the ground deviated from this common pronouncement early on, and divergence is so great today that sustained consideration of postmortem privacy is essential. Yeah, I mean, this is really interesting, especially because we have a large footprint now on social media.
Yeah.
So when I die, I have created a lot of information, on LinkedIn, Facebook, Twitter, all sorts of places. That stuff, I mean, this podcast, for instance, is on the internet as well. So that stuff lives, even though you have gone away, right? So
Yes.
so what is our current understanding of this?
So there's remarkably little clear cut legal governance of the privacy of the dead. The purpose of the paper Postmortem Privacy that Professor Jennifer Rothman and I are publishing in the Michigan Law Review, it's forthcoming. This is my most recent work, so it's appropriate perhaps to end with this paper.
Yeah.
But the problem is that for so long, judges have been saying, oh, if you don't have feelings and sensibilities, you can't have privacy. But now
Hmm.
we see people, as you say, passing away with huge digital assets in their social media accounts. And what happens to all that information is potentially valuable to not just the family, but also to researchers or to the social media platforms themselves
Hmm.
who has a claim. And so we're struggling with this, and there's not a lot of, again, clear cut law. Some of the social media companies are saying that they have an obligation to not release the data to family members unless the deceased has specifically indicated that they would like that to happen when they pass on. But then there's some family members who believe that, well, just as when you leave behind a car or clothing or jewelry, it passes
Hmm.
on to your heirs. It passes on to the heirs automatically, whether they've agreed to it or not. So that's an ongoing debate.
Hmm.
Other, though, interesting dimensions of this are things like the reanimation of celebrities. So Michael Jackson is dead, but the Michael Jackson hologram performs, or the and who has the right to create holograms or other
Hmm.
AI AI enabled technologies that bring celebrities back to life. And not just celebrities, there are people now who are looking forward to being able to talk to their deceased husbands and wives and
Yeah.
have their deceased pets reanimated. And some of it, it's,
Yeah.
I don't care about reanimating dogs, but I do care about reanimating grandma and grandpa and brother and sister and husband and wife, because it seems to me that there are deep questions about the health and privacy
Hmm.
that are of the deceased, that we haven't really worked out, and the technology is threatening to get ahead of us, a little bit.
Yeah.
Maybe that these opportunities are being presented before we've had a chance to really think it through. One example I can give you that's in the paper is that some parents of children who were killed in school shootings allowed their children's voices to be recreated um, using AI, and then the children spoke to Congress in opposition to resistance to gun control. They spoke in
Hmm.
favor of gun control to Congress. And I think, well, I mean, do parents really have a right to recreate the voices of their children in AI and have their children become
Hmm.
tools of politics, to speak on behalf of a cause.
Mm.
So these kinds of questions I think are very important, and I think often engineers aren't the ones who are they're creating the technology, but they're not asking the hard questions. And so as a lawyer and a philosopher, I want to keep some of these hard questions on the table, and I want to excavate hard questions that maybe aren't on the table, but that should be on the table, including the questions around how we show respect for the dead.
Yeah, it's really important topic. I haven't really thought through it. So there's an intermediate position, perhaps. I just threw this out for you to think about. So suppose you're in a coma or in a
Hmm.
vegetative state. You're not dead yet. Is there a difference?
Well, I think there is a difference. Uh, because uh, let me take a step back. If you're in a permanent vegetative state where
Mm,
you'll never recover higher brain function, then I think you are essentially already dead. And I think the same analyses that apply to the dead should be applied to people who are in vegetative comas. Um, which is to say that family members should be allowed to produce evidence of what they would have wanted, and that could then be used to govern what happens to their bodies. That's already going on. Family members are allowed to say, well, she would have liked to have been had life support terminated if this happened to her. I know because
mm,
she wrote me a letter saying that, or it's in her living will, or whatever. So that strikes me as being a similar problem. But for people who are in temporary comas, or temporary,
mm,
not certainly in a permanent vegetative state, then I think it's a little bit harder to know whether how we treat them. I think we should treat them like sleeping persons and not like the deceased, right?
mm,
So but I get your question. And the famous Michael Schiavo case where the guy down in Florida wanted to terminate nutrition and hydration for his wife who was in a coma. He was thoroughly criticized by the Right to Life movement for in a
mm,
sense essentially wanting to kill his wife and get on with his life. And the question of what she would have wanted was not able to really get a proper hearing because she was a young woman who'd never really clearly indicated her wishes about her remains, right?
mm,
So he was but he, as her husband, he was given the right by the court to make those decisions about
mm.
about his wife. It's I think that in the future, and my co-author and I do suggest that we encourage people to be a lot more specific at a lot earlier stage in their life about what they would like to see happen to their digital assets upon their demise, and what they'd like to see happening to their body upon their death. Because unless we have that knowledge, then you're going to have these tragic cases of people perhaps being exploited, abused,
Mm.
um, mistreated in their death. And where some people believe that the dead don't have any interest, my co-author and I argue that the dead do have interest, or at least the future, our future dead selves have an interest, which we right now
Yeah.
as future decedents can protect and act to protect.
Yeah, I mean, it's a very practical question. So in a will, you typically talk about real assets, real estate, buildings or
Hmm. Hmm.
homes and things like that.
Hmm.
We might find ourselves in a situation that most of the asset value of an individual is electronic. So, so do you think the wills, I mean, the legal procedures we have in place today is sort of antiquated already?
Yes, it is antiquated. Because what's going to be left behind when you and I pass on are going to be bits of data that we have either posted on social media, or it's been posted on our social media,
Yes.
and it's not something that can be held in the hand of our children or our grandchildren, right? But it may have economic value, but it may not. We don't know. So it can't be it needs to be its own category of property or of assets. Somehow it needs to be its own category, and coming up with a framework for that categorization or language to use to describe that is something which we're still working on as a society.
Hmm.
It's a strikingly vivid problem, and one that I hope we can make some progress in the next few years, because it's already becoming a huge
Big issue,
Problem.
yeah.
Yeah, especially for celebrities because of their
Yes,
their intellectual property. Their the value in their identities
yes,
we know very monetizable. Yeah,
yeah.
right.
Excellent, excellent, Anita. I really enjoyed our conversation. Thanks for coming on and
And thank you for
talking to me.
having me and for hitting on such a large range of topics. Thank you.
Thank you.
Take care. Bye bye.